Mr. Cross, you're right.
I'll try to be relatively brief. I want to start at the outset by clarifying the issues here. I think we're more or less in agreement on how this should be framed under that intelligent principle standard that we got from the Supreme Court. But Mr. Delaney separates the complaint into the first four counts being under the non-delegation doctrine and the fifth count being under the vesting clauses. I would argue that he's trying to draw a distinction where none exists. I mean, these doctrines are saying the same thing. These are all sort of supported by the notion of separation of powers. We know that because Article 3, Section 2, which gives us our separation of powers, they're cited by the plaintiff in the complaint in support of both theories. So, and those doctrines are essentially the same thing. They're saying, as Mr. Delaney is arguing, that there are these clear delineations, these three equal branches of government are siloed. Legislature writes the laws, judicial interprets the laws, executive executes the laws, and those lines cannot be crossed. But I think the court has at least implicitly acknowledged this. That's just not how democracy actually works. There's often blurring of lines between the three equal branches of government. So I would argue that there's no claim under the vesting clause. I found absolutely no authority for that in Michigan. There's not a single case that relies on the vesting clause to validate the statute. Not one. So I think we agree that the non-delegation doctrine and the intelligible principle standard that the Supreme Court gave us is what applies here. So, I can understand it. It's an easy argument to make. The plaintiff wants to just rest his case on T&D and Associates, Henry certified questions, and this court's previous opinion. But those involve different statutes, different scope, which I'll talk about in detail in a little bit. But a different outcome is warranted here based on the scope of this delegation. So,
Well, I know you have full time here, and we need to go past the hour that I allotted, we will. But during the scope, how do you interpret 2437? I cited it, replied Iron Pig, I'm sure you examined it. How do you examine that? What does that statute mean?
2437 wasn't part of the complaint.
No, it wasn't. It was cited in the reply in terms of bringing up the argument by Iron Pig that if the local health department has it, the state health department has it. In other words, when the state health department relied upon 2253 after the governor's orders were struck down by the Supreme Court, it seemed to be Iron Pig's fear that if 2253 is no longer valid, and it's not, that then the health department will rely on 2451. It seemed to be the argument that even the state health department can rely upon 2437, which says that the department, the HHS, can exercise any power vested in the local health department. So how do you interpret that? Do you believe that that statute says the state health department can exercise any power that the local health department can? And if so, does it impact your analysis?
It doesn't impact my analysis at all, and it wasn't cited in the underlying order that is at issue in this case. I know it was cited in the response brief, but my next point was going to be the justiciability argument, and that is a clear example of there's no actual patient controversy. It's never been relied upon. It's pure speculation that it would be relied upon. So my argument would be that it's not before the court, it's not right, it's not something that we're here to decide today, but
I'll assume I disagree. What do you think the statute means?
I mean, I would agree with that interpretation, but
What interpretation?
the interpretation that the health department on the state level could exercise any authority that the local health department could exercise.
Well, help me understand this then, because I took your argument in your brief and in your motion for summary disposition to be that, as you started with today, the reason that any analysis that I had in my prior opinion, or the T&D Associates had, because they focused on 2253, is really misplaced because the scope of 2453 or 2451 is limited to the local health department, right? So the scope, it can't affect the entire state, the entire economy. It can only affect the 3 or 4 county, whatever it is, health department of Northwest Michigan.
That was the argument.
If the state health department, though, can exercise the power that the local health department has, how would that be limited in geographic scope any longer?
Well, if it's, we're talking about the state exercising the same powers that a local health department could exercise. They can only exercise those powers within their territorial area.
The state has the entire territory of the state of Michigan.
It does, but in that scenario, it wouldn't be it wouldn't be exercising the same powers that a local health department has within its locality. Again, we're talking about something that the MPHHS may conceivably use as a basis for an order. First of all, I understand you just want to answer the hypothetical. It hasn't happened yet. But if it does happen, I think we fall back under the same analysis that this court applied and T&B Associates applied regarding 2253, because it's a different provision, but we're really talking about the same thing, the same broad geographic scope. So, and the intelligible principles doctrine, that standard, the analysis is different. But we're not dealing with that. We're dealing with something that a local health department did just in its 3 or 4 county geographic area. So,
right. But the question, of course, as you told me in your brief, and I'm sure you're going to repeat today, is it comes down to analysis of the scope, the amount of the delegation, the duration, and all sorts of factors that are under those intelligent principles. So the scope being an important one.
right.
So if it's limited to the four counties of the health department of Northwest Michigan, that's significantly different than if it's potentially statewide.
Right.
Again, that's why I'm asking if you agree that 2437 would give a state department health officer the ability to rely upon any of the local health department. Because that's what the statute appears to say to me. 2437 appears to say to me that if the local health department has the authority to declare an epidemic and ban the gathering of people, then the state can rely upon that local health department and exercise the authority within its jurisdiction, which is the entire state.
Right. Well, we're dealing with different scenarios, because you're talking about essentially the state relying on 2437 to take the rationale. I can go in the health department of Northwest Michigan's territory and do the same things that it could.
I see. So you're viewing it as a state would be limited to exercising authority within the boundaries of the health department of Northwest Michigan.
Right, and I understand, of course, hypothetical to be what if the state expands that to every single health department. And then I think, again, we fall into that analysis we talked about before, the previous analysis applied by this court and T&B Associates, because we're not dealing with a geographic, limited geographic scope. So I think the analysis would be the same if that hypothetical ever actually came to pass. Because again, we're talking about a large geographic scope. They may rely on 2437 to expand this logic to every single one of the health departments. But if the state did step in and only in the locality did what the local health officer has the power to do under 2453 or any of the other statutes challenged, then I think the analysis is the same as I advocate for in my brief, because we're talking about a limited geographic scope, and as I'll touch on a little bit, temporal limitation too. This is not boundless power. There are limits. So hopefully that answers the court's.
It does. Thank you.
All right, thank you, Judge. So just turning to the arguments that are in the brief, and I'll be very brief on the first one because I do acknowledge that the court probably feels like its hands are somewhat tied by the mootness, the justiciability argument because of T&B Associates. But
Well, you seem to acknowledge that in your brief. I know you, like Mr. Delaney, are also arguing that you think that case is wrongly decided. You're free to do that, of course. But I think it seems to me you're conceding I'm bound to find that there's not mootness because the very health statutes that were cited that are being attacked by Iron Pig were used against Iron Pig before.
right, I agree with that, Judge. This was honestly more of a preserve for appeal argument. But I did point out that, for what it's worth, again, I understand that the court's hands are somewhat tied by the higher decision. But if you look at what other states have done, understanding it's just persuasive authority on this court, they've pretty resoundingly said when these orders have been decided that there's no justiciable, there's no actual case or controversy. So I don't want to even belabor that point any longer. Mr. Delaney acknowledged it. I mean, in the Flynn opinion, the court confusingly sort of acknowledged that it was moot, but then went on to address the merits anyway. So I don't really have any further argument on that. So the first argument, turning to the non-delegation doctrine, again, there's really two things the court needs to decide. I think it's a threshold matter we have to decide. Does that doctrine even apply to a locality like the health department? I cited, in the cases I cited, they speak in sweeping terms about Article 3, Section 2 of the Health and Local Government, and that is taking plain language in that section, that it only applies to state and local government. So I read the response obviously and the attempt to distinguish the cases I cited. I don't think they really did so in a meaningful way. I think it's clear that it doesn't apply to a local health department. And take a step back too, because I wanted to just establish one sort of foundational principle about the non-delegation doctrine. The version of it that's advocated for by the plaintiff here. Again, it's that strict silo. You cannot cross the lines. But that's just simply not what happens in practice. The line between the three branches just quite blurry. And I promise I'm not going to read you a bunch of quotes they did, but there's one from the Mayor of Detroit versus State case that I thought maybe just kind of encapsulated this point perfectly. That's not much of a standard, and the executive protection essentially monopoly for up to 14 years. And just one more example, in 1790, they delegated to the executive the power of disabled veterans to the pension rules. And in doing that, they said that he could, quote, add to the list of invalids of the United States at such rate of pay and through such regulations as shall be directed by the President of the United States for the time being. Again, very, very broad delegation. It's the executive's ability to choose who gets the pension, how much they get, how they get paid, and how those funds were drawn from a limited pool of resources. So, obviously, these aren't relics of the past. Delegations happen all the time. I read you one delegation, and we look at here in this quote. The Michigan Supreme Court is empowered to enact rules of procedure in court, and even enforce those rules. If I were to get out of hand here, you could hold me in contempt. You have some enforcement power as well. Of course, we have one example here in the Public Health Code. Another easy example is Minotia here in Michigan. They pass their own rules, enforce their own rules, they even serve a quasi-judicial function dealing with initial appeals. While that does ultimately go up to an administrative law judge and then need to assert the court beyond that, that is pretty broad authority to give an executive agency like Minotia. So turning to the actual test itself, the courts acknowledge is really what applies here, and that's the intelligible principle test. So, and again, I think this is my other quote that I'm going to read for you, Judge, but in the in-race certified questions case, they said, no valid objection can be made to delegated authority or discretion as to the execution of laws. And, quote, a certain degree of discretion and thus lawmaking adheres in most executive or judicial action. And that comes again from the in-race certified questions case 506 mesh at 358. So generally, you know, the legislature in enacting the law, it'll give you this broad, and I'll talk about what that is the public health code, this broad overall goal. This is what we're trying to accomplish with the public health code. And then they set in place sort of guardrails to guide the executive's hand as they implement that overarching policy. So again, we look at whether the legislature, in delegating a certain amount of rulemaking authority to the executive, gave that executive intelligible principles to follow. So in doing that, and this is just sort of a summary of the case law that I cite in the brief, but there's certain considerations that the court wants us to take into account. And the first is that we have to read the act as a whole. You can't just read these provisions that plaintiffs cited in the complaint in isolation. We have to read it as a cohesive law. We have to apply a presumption of constitutionality. We can't go out of our way to find a constitutional defect when there's a reading of these statutes that would render them constitutional. We have to take into account the complexity of the topic that's being regulated. In this case, epidemics, contagious diseases. So the level of precision required in that delegation is going to be a factor when we're looking at whether that delegation contains intelligible principles. So that the standards must be broad enough to permit efficient administration, but obviously not so broad as to leave people unprotected from uncontrolled or arbitrary power. So I just want to pause here for a second because I think part of the argument that is at the heart of this case is that this is, the plaintiff thinks that this is the only recourse that it has to avoid being subject to these laws, and that's certainly not the case. You can anytime file a substantive due process claim. There are ways to challenge the administration of this law. I understand that's what they're trying to do here. They're trying to attack the very reason that the local health officer has this authority in the first place. But if they do find themselves subject to one of these orders, that's always an avenue available to them. But of course, understandably, they want to avoid that standard because
They already had to do it.
yeah, well, not with this order, not with the local health officer order, but I understand that this is the mechanism for them to challenge this order. If they think that it's being arbitrarily, capriciously applied to them, that's always an avenue available to them. But of course, that means all the health officer has to do is articulate a rational basis for why the order was put in place. I understand that's not why we're here, it's postured differently, but it is important to acknowledge that, I mean, this is something that they can always challenge if they are subject to a future order. But and the court's acknowledged just a couple times, the scope is relevant, and we're talking not only the geographic scope, but the temporal scope. How broad is it covering the entire state? Is it the locality? Is it indefinitely, or are there some parameters on how long the order can be in place? So just general principle is that if it is a broad delegation, because one's at issue and they certify questions and review associates statewide impacting the entire economy, we need to have some pretty precise standards there. But the exact opposite is true. That's something the court acknowledged too. If it's a narrow scope of delegation, we don't require as much precision in that situation. So it doesn't weigh directly on the intelligible principle standard, but I cited in our brief the Jacobson case. It's a United States Supreme Court case that's over a century old. And the primary reason why I cited it, it dealt largely with what I think is a big motivator for this case and cases like it, and that is the tension between individual liberties and the common good, the community's right to combat against infectious disease. So, like Jacobson, and I laid out in the brief too for the court's considerations that Jacobson is trying to take into account when we're dealing with laws like this. But so what the court in Jacobson said, I guess I lied. I have one more quote for you. The court noted, quote, "In every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand." So, end of quote. So, in the Jacobson case, that was arguably a far more severe law than we're dealing with here. In that case, it was a vaccine mandate that allowed the state to fine someone for not being vaccinated. And the standard there, I think, is worth highlighting too, because the only standard on that the Massachusetts law was someone had to be vaccinated if the local board of health, quote, found it necessary for the public health or public safety. Very similar language. That is a theme that permeates all of the public health code, because this type of flexibility that we're talking about here is necessary to address rapidly evolving crises like an epidemic. So we see that this is language that's used in a lot of the other cases from other states that I cited. But ultimately, the court upheld that law in Jacobson. But it did say, similar to what I'm saying here, is that there's always that arbitrary, capricious standard. And Jacobson essentially said incomparable law has to be reasonable and proportional. So, with those background principles, I'm just going to talk very briefly about the specific challenges in this case. So, I don't think anyone in here needs a reminder of what it was like in a really chaotic, even public officials were struggling to get their heads around. They did community. Specifically to the public health general process of the legislation will say this is our overarching goal, here are the parameters that we want you to stay in. So that goal of the public health code is to protect the safety and welfare of the people of the state, and the legislature even said in MCL 333.1111, parents 2, that we should liberally construe the public health code to achieve that goal. So I would argue first and foremost that it would be impossible to achieve that very lofty goal without affording local health officers a certain amount of discretion and authority to implement the public health code in their locality. So we have to consider too who this person is. Who is the local health officer? This is consideration that I believe it was the Indiana court that I cited in my brief that they focus very squarely on, because this isn't just someone off the street who's guessing at what might be the best thing to do to avoid the spread of disease. The public health code itself and the administrative rules implementing the public health code spell out some very specific criteria for what these people, what education and experience they have to even be the public health officer. So they have to have years of public health experience, and that's better position, certainly than me or the court or the legislature or the board of health even, to know what is necessary in the locality. It's informed by those years of education.
I don't understand how that matters. I understand logically, emotionally, having somebody who's well qualified, and assuming your directors of the health department are, to make those calls. That really doesn't answer the question, the legal question of delegation, and whether or not there's proper channeling of the exercise of discretion, right? Because no matter how qualified the director is, either there's adequate standards that challenge or that channel the exercise of discretion, or there's not. I might be the most qualified health officer in the entire country, but I can't withstand constitutional challenge if there's not the guideposts. So tell me about the guideposts.
Right, and that's what I'll turn to, but I appreciate that comment, and I understand and agree, Judge. It's simply one factor that other courts would face with non-delegation doctor challenges. That's one factor they take into consideration, and I primarily mentioned it just to give the court some background and some comfort to know that this is not like, this is someone who, more, you know what they're doing, but I agree with you.
I didn't take any of Iron Pig's challenge in the first case or in this case to be with individual health determinations or individual health officers or whether or not they were qualified. I took it to be strictly legal attacks on the framework, the delegation, whether it can't withstand constitutional scrutiny. So I understand what you're saying. There are other cases that have mentioned specifically the training that's required as being essential to, again, starting with that proposition when we look at the act as a whole. We look at the act as a whole. But I think it still has to get down to, and I think you can acknowledge this, the average legal standards, the scope, the durational length. So with respect to those, help me understand how their discretion is channeled by these statutes.
Right, and I'll turn to that and I'll address each statute cited individually. So we'll start with what is the focal point. This lawsuit, and that is section 3. And just for clarification, it says that the local health officer determines that control of an epidemic is necessary to protect the public health. He or she may, by emergency order, prohibit the gathering. So applying those intelligible principles that we talked about before, my argument is that it withstands constitutional scrutiny because, again, we're reading this as a whole, as the District College, and first of all, the scope of the health officer is geographically limited. We didn't talk about that before. It's only the locality covers, in this case, this multi-county area. And again, that makes it very, very, very different than in-rate by questions and TMB. So it's certainly warrants an analysis and I believe a different outcome here. And my argument is that it is temporally limited. This is not indefinite power because it's limited for the period of time in which there is an epidemic and such measures are necessary. Now, I know I need to stop there because reasonable, necessary, these are words that they give plaintiffs some disease, and I understand that. But I want to focus first on epidemic because in TMB and in this court's previous opinion, there's a lot of focus on epidemic and the fact that it's not defined in the public health code. But I would argue that, again, reading this as a whole, applying that presumption of constitutionality, it's absolutely clear what it means in this context. Because let's cite to some of those examples that TMB associates in this court cited before as things that are referred to as epidemics. Loneliness, obesity, teen vaping use. Okay. Let's bring it back to 2453. This specifically says local health at the gathering of people. In what world would they apply that to teen vaping or obesity? The health officer is not passing orders to prevent obese people from gathering. That's just not what the power is for. So I would say that while it's not defined in the public health code, if we look at the original understanding of what an epidemic is, etymology of the word, it deals with communicable diseases. And that starts to make a whole lot of sense when we look at the fact that it's allowing the health officer to limit the gathering of people. And in COVID, of course, that made a whole lot of sense. I mean, this was a communicable disease that at least we use spread from person to person. So I would argue in context what epidemic means is clear. So
I can't really look at that though, right? I have to look at the language of the statute. I can't interpret it if it's clear and ambiguous. And it says epidemic, but it doesn't provide a definition.
Right. If you come to the conclusion that epidemic in this context is ambiguous, we look at the dictionary definition of that term. And I understand that if you were to look it up, because I looked at it yesterday, there are some of those same sort of broad what an epidemic means, and it will refer to it in a more figurative sense of just like a widespread condition. But again, reading it in context, reading it as a whole in the public health code, I think it's clear, even if we look to the dictionary definition, the common understanding of what epidemic means, I think it's clear in context. So those are really, I mean, those are the factors that we apply, intelligent principles factors, and I think based on, again, the limitation on geography, the limitation on time.
What is the limitation on time?
Again, distance of determination. The statute, and again,
It's open.
not before. I think the medical community has designed to pass epidemic status at this point, but I know that in an ideal world, yes, epidemic explicitly default the health code, but how do they define that?
Wasn't the question better put that if it was defined, it would be less broad of delegation? Because it's not defined, it's a great delegation of power. Because we use the definition to the sole person deciding what is an epidemic or what is qualified.
I would say, yes, of course, in the absence of the definition, yeah, it's of course broader, but not unconstitutionally broad. Again, considering all of the intelligible principal factors, there's enough here to cabin the authority of the health officer, and there always